At Raju Law, we don't just provide legal services, we provide a pathway to your American dream. With offices in New York, Los Angeles, Washington, D.C., Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every stage. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving your time while upholding the highest standards of quality. At Raju Law, we believe in affordable, transparent pricing without compromising on service excellence. Raju Law, where your American dream meets expert legal support. Contact us today.
Hello and welcome everyone. I am Sudiksha Bohora and I'm absolutely delighted to have you with us for another episode of Immigration for All, brought to you by Nora Global and proudly powered by Kulatech. If you have been tuning in, you know that we have recently rebranded our Modern Life series to Immigration for All, a name that truly reflects our mission to make immigration knowledge clear, accessible, and practical for everyone, no matter where you are in your journey. And here's some exciting news. Our show is now officially available on Spotify and Apple Podcast. Whether you are commuting, working out, or just winding down at home, you can catch all our episodes anytime and anywhere. In today's episode, we are diving into a topic that's been gaining increasing attention, especially among the individuals currently in the United States under asylum status who are exploring educational opportunities. How to change from pending asylum to F1 student status. This is a very complex and nuanced process with many legal considerations such as eligibility, timing, and risks. For many asylum applicants, pursuing education while maintaining lawful status can open up new pathways and possibilities, but the transition from pending asylum to F1 status may be approached with clarity and caution. Now, without further delay, let's welcome our special guest, Mr. Raju Mahajan, Principal Attorney at Raju Law. Mr. Mahajan is a seasoned immigration attorney with deep expertise in the asylum and student visa matters. He has guided numerous clients through status adjustments, including navigating from a pending asylum case to obtaining F1 student status.
Hi, Shudiksha. How are you?
Hello, sir. I'm fine. How are you doing?
I'm good, good. Thank you. Thank you for hosting this event today. All right. So, without further delay, let me go to the topic. Let me add slides to the our screen, and also those who are listening to our podcast. Don't worry. Anything that is in the slide, I'm going to read it, so you're not missing anything. And as Shudiksha said, this is a very complex matter. Many people here in America, they applied for asylum. Their case is pending. They do not have any other visa status, and they asked me this question a lot recently. They say, "Hey, how do I change my status from asylum to F1?" Now, before I start talking about this, let me tell you, this is a very, very complex, and the success rate is very low. It doesn't mean that you cannot do that. Of course, you can try, and very people are successful about doing this. But this is a very complex and very rare kind of situation. I must tell you. So let's go to the actual discussion. Before actual discussion, so the pending asylum means someone who applied for asylum application and it is still pending. Either they did not get approval or denial, they're still pending. And F1 means like a student visa. I'm pretty sure everybody know about the F1 visa, but those who do not know, F1 means student visa. And our today's presentation is going to be a short one because it's not there's not a lot of things to talk about it, so it would be a comparatively short presentation. All right, so there are primarily two ways to change your status from a pending asylum to F1. By the way, one thing I must clarify here too, pending asylum is not a status, it's a stay. It's a valid stay. when you come to America with other kind of visa, like F1, B1, B2, L1, O1, or any kind of visa, they give you status. You are in F1 status or O1 status or B1, B2 status. That's the status. But when you apply for asylum, pending asylum is not a status. It's a valid stay. Now, what is the difference between valid status and valid stay? Nobody knows. This is the legal fiction. And there's a lot of legal fiction in legal world. I'm pretty sure you know about that. If you do not know, if you can just Google it, what is legal fiction is, or you can YouTube it. That's a whole new discussion. I'm not going that detail into legal fiction, but difference between legal status and legal stay is a legal fiction, meaning there is no concrete answer to what is the difference between valid status and valid stay. So when I say change of status from pending asylum to F1, what I actually mean is changing your valid stay from pending asylum to changing your valid stay from pending asylum to a valid status of F1. That's what I actually mean. But just for the sake of argument, I'm just saying change of status, just to make it easy for you to understand. All right. So as I said, there are two major ways, primary ways to change your status from asylum to F1 one is change of status from within the US, from US, so you do not need to go outside of America. And another one is applying for a F1 visa from a US embassy or consulate abroad. You're going outside of America, you are applying for F1 visa in a US embassy or consulate, and then if you get visa, you come back to America again, kind of thing. And I'm going to discuss both. The first one is change of status within the US. So this path is extremely limited and rarely approved, as I said in the beginning, due to the following reasons. So there are some reasons why this is extremely limited and rarely approved. Number one, intent conflict. So anytime you apply for a non-immigrant visa, like F1, B1, B2, L1, O1, or anything, you need to establish a non-immigrant intent, meaning you're coming to America for a certain purpose, and once the purpose is done, you are going back to your home. This is the summary of non-immigrant intent, meaning you do not want to stay here in America. On the other hand, when you apply for asylum, you say American government that, hey, I have difficulty in my home country and other countries, I want to stay here. So asylum application comes with the intent to stay here, and non-immigrant status like F1 application comes with a non-immigrant intent. So when you already show intent under asylum application, it's difficult to show a non-immigrant intent, especially when the immigrant intent application is pending. So if you can withdraw the asylum application and then apply for F1, that's good. Then you already withdraw your immigrant intent and then applying for non-immigrant intent, that's good. However, then if you withdraw your asylum application, then you are going out of status. That's another problem. That's a different thing. I'm not going to discuss that thing today. I'm just saying, while your asylum application is pending, your already immigrant intent application is already shown to US government. Parallelly, it is difficult to show a non-immigrant intent because these two intent conflict with each other. And in the conflict between an immigrant intent and non-immigrant intent, always immigrant intent will win, meaning your pending asylum application will win, and your application to change to F1 will be denied, kind of things. I'm not saying for sure this is the big issue. I'm just saying. The second thing is must be in a valid non-immigrant status for change of status, as I said earlier. So when you apply for a change of status, you must be in a valid non-immigrant status. As I said, pending asylum application is not a valid status, it's a valid stay. That's another problem for change of status from pending asylum to F1. Also, approval of change of status may result in the denial of your asylum application. So if the USCIS officer says, yeah, that's fine, if you want to go to F1, I'm going to approve it, then they are going to cancel or deny your asylum application, because these two cannot be parallel, right? So sometime if your F1 application may approve, but they may deny your asylum application. That's another risk, because a lot of people, they want to keep both. They want to keep like a parallel. That's the problem. So this is extremely rare to keep parallel both. You may get F1, but then you're going to lose your asylum. And even if you meet all the conditions, approval is still rare and at the discretion of USCIS officers. What it means is USCIS officers has broad discretionary power to even deny your application, even if you meet all the requirements. That's crazy, I understand, but this is what it is. So it's in the discretionary power of USCIS officers. So I hope you understand this matter. All right, now we're going to the second option, which is F1 visa from a US embassy or consulate abroad. So under this option, what do you do? So let's say you have a pending asylum application, you apply, you get admission to a US university here in America, and then you apply for F1 visa in a foreign US embassy, and that can be your home country, that can be a third country too. So let's say you are from India, you applied for asylum, it's pending, and you got admission to, let's say, ABC University, and then you applied for a F1 visa based on your ABC University admission, and you applied to US Embassy in Canada. That's okay. You're not going back to India, you're going to Canada, which is fine. So the way to do it, you don't have to leave early. What you can do, you can apply for F1 visa, and if they schedule, sometimes they may not even schedule because you're not in Canada. You do not have a valid Canadian visa. That's another challenge. But let's say, for the sake of argument, they took your application, they schedule interview, and then what you do, you apply for I-131, which is an application for travel document. With that travel document, you go to Canada, you face F1 visa interview, and then if it get approved, you come back to America with a valid F1 visa. Now there's another, the non-immigrant intent challenge is still there, because when you have a pending asylum application, your intent to stay in America is still shown, and then you're applying for F1 visa, which is a non-immigrant visa. So this conflict still remains there, even if you go out a foreign embassy or consulate, and the consular officer, given the history of seeking asylum, consular officer may deny your F1 application, or if they approve your F1 application, they may deny your asylum application. So they may deny either of these two applications, and then you may have a approved F1 visa. You can come back to America with the approved visa. However, there may be some difficulty returning to US at the port of entry, because you already applied for asylum one time. This document will remain there. Even though you withdraw the application or your asylum application is denied, the document will remain there, right? Because US government will always see that you applied for asylum sometimes. So sometimes, especially the current administration, current situation, there may be some difficulty returning to the US at the port of entry. So this challenge will remain there. All right, so one better option, and I see that it happened a few times, and this is a comparatively better option. So let's say husband and wife, one spouse apply for asylum, and the other spouse do not join in this asylum application. Please remember, the other spouse do not join the asylum application as dependent. The other spouse maintain his or her F1 status. So one spouse in F1 status, another spouse is in pending asylum. And then this is the better option, because down the line, when it will be time for green card application, the spouse who is in F1 visa can apply for, let's say, EB3 or NIW, EB1 or other kind of green card, get green card, and later, after getting green card, can add the other spouse who is in pending asylum later as a dependent. So this is the kind of better option, but again, it comes with a lot of cost. Another thing, you have to maintain your F1 status. You have to pay tuition. Another thing, you will not get work permit outside of campus. So those are the other things. I'm not going that detail into those things. As I said, this is a comparatively better option. So let me summarize what I said today in this short presentation. Changing your status from pending asylum to F1, while technically possible, converting from asylum to an F1 student visa is extremely difficult under both change of status and consular processing. The immigration history tied to your asylum claim poses a major challenge, especially concerning the non-immigrant intent required for F1 eligibility. So that was my short presentation today. If you have any question about anything, please let us know. We'll be happy to answer. Going back to Sudiksha.
Thank you so much, Mr. Mahajan, for such a thorough and insightful presentation. You have made a complex legal transition more understandable, and I'm sure our listeners now have a much clearer picture of what's involved in changing from pending asylum to F1 status. So before we move on to our live question and answer session, let's take a very short break. So stay right here. We'll be back in just over a minute.
Are you a leader in your field, an innovator, artist, scientist, or entrepreneur? You may qualify for the prestigious EB-1A Extraordinary Ability Visa, your fast track to a U.S. green card with no job offer required. At Raju Law's Dhaka office, we specialize in building powerful EB-1A petitions tailored to your achievements. With expert attorneys, global experience, and a tech-powered process, we bring U.S. immigration success to your doorstep. Your extraordinary talent deserves an extraordinary path. Let Rajula Dhaka open the door to your American dream. Book your consultation today.
Welcome back, everyone. It's time for our live question and answer segment where we answer most of your pressing questions. We have received several thoughtful inquiries from viewers, ranging from concerns about timing and processing delays to what happens if the asylum case gets decided while the F1 application is still pending. So, Mr. Mahajan, we're excited to hear your insights on these real life scenarios.
Yeah, thank you. And there are a couple questions. Those are written in Bengali. Let me read that, and then I'm going to answer it English. And if there's any other question from English, you can read it later. So the first
Okay.
one, Mr. Mohammed Roman, আমি রোমান আমেরিকান সিটিজেনশিপ আমার লিগ্যাল আমেরিকান সিটিজেনশিপ আমার লিগ্যাল গার্ডিয়ান আমেরিকান সিটিজেনশিপ আমার বয়স যখন 6-7 বছর তখন আমার আমেরিকান গার্ডিয়ানশিপ আমাকে বাংলাদেশে বয়স্ক লোকের কাছে রেখে গেছে আমার আমেরিকান পাসপোর্ট আমার যা কাগজপত্র ছিল সব আমার আমেরিকান গার্ডিয়ান রিটার্ন আমেরিকায় নিয়ে চলে গেছে আজকে অনেক বছর হয়েছে আমার সাথে যোগাযোগ করে না আমার গার্ডিয়ানশিপের সাথে যোগাযোগ করতে চাই আমাকে সাহায্য করুন আর আমার আমেরিকান পাসপোর্ট নাম্বার মনে নাই আমার আমেরিকান লিগ্যাল গার্ডিয়ানশিপের নাম মনে নাই আমার কাছে okay so what he's saying is that he's a US citizen he's living in America since very early age his American legal guardian I don't know what kind of guardian that person is took all the documents so he cannot remember the passport number or anything and also cannot remember the guardian's name so I think it's a little difficult case but we can try to help you again no guarantee I would highly recommend you to contact our Dhaka office and then we may contact US Embassy in Bangladesh on behalf of you and try to retrieve the copy of your passport number, social security number, and other thing, and then we may try to help you. So my recommendation to you is please contact our Dhaka office. We will start working, and we can try. It's a little difficult, but we can try to help you. Next one also wrote in Bangla. Let me read it to Saiful Islam. Tourist visa থেকে student visa যাওয়ার process বলবেন. So what he is asking is change of status from tourist visa, which is B1, B2 to F1. This is comparatively easy. All you have to need is you have to get admission to a US university who can issue I-20. Once your I-20 is issued, you get the I-20, then you apply for change of status from B1, B2 to F1. There are some other requirements, some other documents like proof of finance and other thing. It's not difficult. We can definitely help you. And I think we have a video about this topic in our YouTube channel. So if you go to our YouTube channel, I think I mentioned a step-by-step guideline from change of status from B1, B2 to F1. You can follow that. It's comparatively easy. And frankly speaking, you can do it by yourself too. But if you need our help, we're here to help you. Next one is also in Bengali. Let me read it. Shupankar Borua. ভিজিট ভিসায় গিয়ে কি EB3 ভিসায় কনভার্ট করতে পারবো আমেরিকায় গিয়ে প্রয়োজনে আমার আবার চলে আসবো yes so his question is he wants to come to America with a visit visa and then apply for EB3 yes you can do that EB3 has 3 steps the first one is called PARM the second one is I-140 so in these 2 steps you do not need to stay in America for any purpose you can come to America with a B1, B2 visa, start EB3 process, and then go back to your home country or any other country. In the third step, technically, you can still apply from your home country or any other country. But if you apply from within America, which is called adjustment of status (AOS), which is technically faster, that's why a lot of people what they do, they come to America with a B1 B2 visa and then they apply for adjustment of status while in America. The short answer to your question, yes, you can definitely apply for EB3 after coming to America with a visit visa. There's no problem with that. Next question, even though it's English, let me read it. Adit Hassan, change of approval, requesting change of status from B1B to F1. The same question, someone wants to change status from B1B to F1. You can definitely do that from here in America. I already answered this question. And also we have a video in our YouTube channel. I strongly recommend you watch that video and you'll get a detailed answer. That was from this live question. Sudiksha, if you have any other question from your end.
Yes, there are a few questions I would like to ask. The very first one is the USCIS has issued an RFE regarding my visa level of my H1B petition. How do I address this?
Well, how do you RFE answer a RFE? Most of the time, they mention what they need. So RFE stands for request for further evidence, meaning they need more information, more document from you, and they usually mention with number like a 1, 2, 3, 4. You go by 1, 2, 3, 4, and you send them everything that they're asking for. It's very easy. I mean, by easy, I mean like they already mentioned you what they need. So just send them what they need, and I'm pretty sure they'll be happy about that.
Okay, so there is another question that is, I'm working on an H1B visa, but my employer has changed the job location. Do I need to file an amended petition?
Yes. So change of location, change of designation, change of vital information is very important for H1B, especially the current situation. Everything is volatile. So yes, I highly recommend you to amend the petition and show the latest location.
Okay, thank you. There is a third question that is there any chance of a second lottery of H1B for this year?
I cannot say that for sure, but pretty much every year there's a second lottery, there's a third lottery, sometimes even there's a fourth lottery. So I'm very confident there'll be second lottery this year, but nobody knows for sure.
Okay, so there are some questions related to EB2, EB3 perm. So the first question is, my I-140 is approved by the EB3 application, but I have changed the employer. What happens to my green card process?
This is a tricky question, and I have to see the document because in some situation, change of employer will end up denial of your application. In some situation, you can transfer the application from one petitioner to another petitioner. So I have to see the documents. I have to see the situation here, and then I can answer your question. So what I advise you to take a paid appointment from our website. I can review your document and better guide you.
Okay, thank you. The next question is, my perm was approved, but my employer wants to change the job title. Will this impact my green card process?
It may. The same question like before. If anytime any petitioner, like meaning employer, wants to change the job location, job title, job description, all those vital information, then it may end up, getting your H1B denied. So I highly recommend you to amend your petition based on the new information.
Thank you. The other question is, I'm concerned about my employer's ability to maintain the business throughout the perm process. How does this impact my green card application?
It's tricky. Yeah, if the employer cannot maintain the business, it's difficult. Sometime like after submission of adjustment of status and after passing of 180 days, if your employer cannot maintain their job, that's okay. If it passes 180 days, which is like 6 months, but if anything happens before that period, then you may lose your application totally. So it's very tricky.
Mm-hmm. Thank you so much. The next question is, can I apply for a change of status while my perm application is pending?
Yes, when your PARM application is pending, basically PARM application has nothing to do with immigration. So this is another important information. PARM application is with Department of Labor. It is not with USCIS or Homeland Security or anything. So while your PARM application is pending, you can definitely change your status from one non-immigrant status to another non-immigrant status.
Okay, thank you. So lastly, we have some questions from E2. What if my E2 investment is made with the borrowed funds?
Well, technically, you cannot apply with a borrowed fund. It must be your money, and by your money, you can take gift. So the person who is borrowing you, if the person issue a gift, so the difference between borrowing and gift is that borrow is like as a loan. He or she is giving you money, and you are supposed to return the money. On the other hand, gift is giving forever without any hope of getting return. So with the borrowed money, it's difficult to get approved. I think the better option would be if you can take that same money from the same person as a gift, that has a better chance.
Okay, thank you. So the next one is, what if my E2 business does not hire US workers? Is that an issue?
No, that's not the issue. For E2 business, it is not required. It is good if it is recommended, but it's not mandatory to hire a US employee, sir.
Okay. So the third question is, can I lose my E2 visa if I change business partners or reduce my ownership stake?
Yes, changing business partner is not that bad. You can definitely change your business partner without any hassle. But if your partnership reduces less than 51%, then you may lose your E2 status.
Okay, thank you so much. This was my question, but I think there is another one question in the comment section, and I think it's in Bangladesh language. So can you please read it by Habiba?
Yeah, yeah. Umme Habiba, 2 times rejected F2, কি প্রসেসে অ্যাপ্লাই করলে ভিসা হওয়ার চান্স থাকবে? So what she is saying that she applied for F2 and it has been rejected 2 times. So what is the process of applying? So there is a different process. The same process you applied, you can apply third time. But what I would advise you is to see what are the reason for your rejection, visa refusal, rejection. So what I would advise you to apply for a FOIA application, FOIA, under Freedom of Information Act. Under FOIA application, if US government has any bad information about you, you can see that. And if it is like a right information, then definitely you cannot do anything. But if it's the wrong information, you can definitely can reach out to the department and say, hey, this is the wrong information. It's not right. I'm not that person. It happened many times. Like, let's say your name is Mr. X. When USCIS or any embassy or any department, they did your background check, they got some information from another Mr. X, because there's a lot of Mr. X in the world. So they sometimes do mistake about the name, date of birth, another thing, and they may have some information that is actually not your information. So under FOIA, you can request for all the documents in your name, and then if there's any wrong information, you can try to fix it, and after fixing it, if you apply, you have a better chance. But the application procedure is the same application procedure.
Okay, thank you so much. I think that wraps up our question and answer session. Mr. Mahajan, we sincerely thank you so much again for your time, your expertise, and for breaking down this sensitive and technical topic with such clarity.
Thank you very much, Sudiksha, and thank you everyone for watching us today.
Thank you for joining. And to our audience, thank you for joining us today. Whether you are an asylum applicant considering a return to education or an advocate supporting someone on that journey, we hope this episode gave you a valuable guidance and hope. So, Immigration for All goes live every Monday at 11 a.m. EST, 9 p.m. Bangladesh time, and 8:45 p.m. Nepal Standard Time. So, make sure to subscribe, follow, and mark your calendars. That's all for today's episode, and as always, stay tuned for a few immigration news updates right after this. Until next time, take care, and we'll see you next week on Immigration for All. Thank you.
Welcome to the latest episode of Weekly Immigration News by Raju Law. This week, we brought to you 4 latest developments in the immigration arena. Let's start with the headlines. Supreme Court lets Trump resume third country deportations. DHS and DOJ announced streamlined process for filing illegal aliens. DHS terminates Haiti TPS. Guidance on validity of alien, refugee, and asylee marriages. Let's get into details. The Supreme Court has allowed the Trump administration to restart deportations of migrants to third countries, not their homelands. reversing a lower court order that required migrants be allowed to challenge such removals. The case involves people from Myanmar, Cuba, and Vietnam who had criminal convictions. In a forceful dissent, Justice Sonia Sotomayor warned the ruling could expose migrants to torture or death. Advocates say they will keep fighting the policy, which is part of the Trump's broader immigration crackdown. Moving on, the Department of Homeland Security and the Department of Justice have announced a new federal rule to streamline and expedite the process of issuing fines to illegal aliens. The rule eliminates the 30-day notice period, allows fines to be sent by regular mail, and shortens the contesting process. Fines will range from $100 to $9,970 depending on the violation. The rule applies to individuals who enter the U.S. illegally, fail to comply with removal orders, or ignore voluntary departure agreements. Illegal aliens who self-deport using the CBP Home app will have their fines forgiven. The rule is part of the broader immigration enforcement policy under President Trump's administration. Moving on, the U.S. Department of Homeland Security announced the termination of temporary protected status of Haiti, effective from September 2, 2025. The decision comes after a review of Haiti's conditions, which were deemed to have improved enough to allow safe return for Haitian nationals. The termination may affect many individuals who currently hold TPS, and they are encouraged to explore other immigration options or use the CBP Home app to arrange their departure. The move emphasizes the U.S. government's stance on ensuring TPS remains temporary and in line with national interests. Finally, USCIS is updating its policy manual to require that all marriages between principal asylees or refugees and their claimed derivative spouses must be legally valid under the laws of the jurisdiction where the marriage was celebrated to be considered valid for immigration benefits. This updated guidance, effective March 3, 2025, applies to requests pending or filed after that date and aligns with recent executive orders. The change could impact many asylees and refugees applying for immigration benefits based on marriage.